Ted.
Yeah, I'll call you.
Okay, thank you.
All rise, court is now in session. We'll sharing the day presiding.
Good morning, please be seated. Good morning, ladies and gentlemen. Today it is my duty to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the constitutions of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by jury. You may waive or give up that right and have your case tried by a judge without a jury. At trial, the state of Ohio has the burden of proving your guilt with evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to cross-examine witnesses for the prosecution. You have the right to summon or subpoena witnesses on your behalf. You do not have to testify against yourself. You have the right to counsel. If you are unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you are unable to pay this fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have the right to a reasonable continuance to hire one. This morning, you are not here for the trial of your case. You are here for your arraignment. An arraignment is your opportunity to be informed of the charges against you, for a bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made may be used against you. As your name is called, please step forward. You will be asked when you receive a copy of the indictment or information and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice, and we will complete your arraignment this morning. If your case is going forward by way of information, I will ask your attorney to place on the record that they discussed with you waiving presentment of your case to the grand jury. You will be asked if you understand the charges against you, if you knowingly and willingly sign the waiver, if you consent the charges proceed by information instead of indictment, if you wish to continue to be arraigned by waiving the 24-hour notice and the reading of the information. You will be asked how you plead. A defendant may plead not guilty by reason of insanity, guilty or with the consent of the court, no contest. If you want to plead guilty and you do not have a lawyer, the court will assign counsel for you so that you may have a complete and full understanding of your constitutional rights. Your case will be assigned to a judge, whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with a crime of violence and/or any drug offense under Ohio law, you cannot knowingly have, carry, or use a firearm or dangerous weapon until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges you are being arraigned for today. Even if you have a permit to carry a gun, you are still under a disability until your case is over. Upon indictment, the sheriff who issued the permit shall suspend it until your case is over. If you are over 18 and have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. If you are placed on GPS electronic monitoring or an alcohol monitor as a condition of your bond, you will be required to follow all the rules and conditions of GPS electronic monitoring, specifically any unapproved leave, late return, or being in an unauthorized location may result in your warrantless arrest. Failing to properly charge or not charging your unit may result in your warrantless arrest. Tampering with or otherwise damaging the unit may result in your warrantless arrest. You understand that you may be arrested without a warrant if you violate any bond condition or rule of GPS electronic monitoring. You must sign the GPS electronic monitoring rules, which will be explained to you prior to your release as a condition of bond. When GPS electronic monitoring is ordered as a condition of your bond, you will be asked by the judge if you were listening to these instructions regarding GPS monitoring, if you understand the rules allow you to be arrested without a warrant, if you violate the terms of GPS electronic monitoring, and if you understand that you must knowingly, voluntarily, and willingly sign those rules prior to your release. Finally, pursuant to revised code section 2937.99, if you do not appear in court as ordered after being released on your bond, you may be charged with a felony of the 4th degree. Inmates in the county jail have the right to be present in the courtroom. Officer Eddie.
We're okay here, Your Honor.
Okay, thank you very much.
You're welcome.
You can call the first case.
Start with the jail 693409, Monte Hardy.
Good morning, Your Honor.
Good morning.
Attorney Alyssa Barboski from the Public Defender's Office will enter a not guilty plea, acknowledge receipt of a copy of the indictment, waive reading of it, and any defect in time or service. As to bond, we are asking that that be set. As to counsel, we are asking to be assigned as one of the attorneys on the case as two are needed. We did meet with him in the jail prior to this and have built a rapport with Mr. Hardy, and we are also asking that we represented him in the municipal court, so we are asking in exchange for one of our other cases to be appointed to other counsel that we would be assigned to this one as one of the counsels.
All right, thank you, Ms. Barboski.
Thank you, Your Honor.
Is there a representative on behalf of the state?
Yes, Judge, thank you. Kevin Filiatro here on behalf of the state of Ohio. Your Honor, I understand what the bond recommendation is for this defendant. The state of Ohio is asking for his bond to be set at $10 million. The state gives notice that it will be filing a motion to have him held without bond once we know who the trial judge is. And the reason for that is this: there are no circumstances under which, if this defendant is released, the public is safe. On June 28th of this year, Your Honor, this defendant used a gun that he stole from his grandmother to shoot her in the head in her own home, and then left the scene stealing her husband's bicycle. July 4th of this year, the defendant was at a house on East 80th Street in Cleveland. He was surrounded by police who were there to arrest him on the warrant for felonious assault from Garfield Heights. He knew they were there. He exited the home, got on that bicycle. In one hand were two swords, and in his left hand was that same gun that he had stolen from his grandmother and had shot her with. Police tried to arrest him in a manner in which he would stay safe. And instead, he fired 4 rounds, the first round hitting Officer Jamieson Ritter, killing him. The second round going right past Officer Logan Weber's head. The third round going in between Officer Russell May and Officer Brittany Vajussi. And the fourth round being shot while 5 officers held his hand to the ground while still clutching the gun. This defendant poses an immense risk to the public and should not be released. With me today are members of Cleveland Police, Russell May, Logan Weber, Detective Hudson with the Homicide Unit, and other members of Cleveland Police. I've spoken with Beatrice Porter's husband. She is this defendant's grandmother, who he is now alleged to have killed. She died later that same day on July 4th from the gunshot wound. I've also spoken with Officer Ritter's family, and here's what they would like the court to know. We wish that he be prosecuted to the fullest extent of the law and he get the highest bond possible. And they have faith in the criminal justice system. Your Honor, with that said, I've heard the state's recommendation. Thank you.
Thank you. Mr. Hardy, could you hear everything that was happening in the courtroom today?
Yes, I can. Do I have permission to speak freely?
I would advise you not to speak on the indictment or any of the allegations in this case, but you may go ahead.
Mr. Hardy, this is Attorney Alyssa Barbosky. Remember when we talked on Friday, how we just said we're just going to go through everything and enter a not guilty plea and we don't wish for you to talk at this time? We'll come visit you in the jail for a sign to the case and we can talk further, okay?
But I do want to pull up evidence from my laptop and my cell phone.
I don't want to talk about that right now. We can talk at a later time about that, okay? That's not appropriate for this morning, okay?
All right.
Thank you.
All right, Mr. Hardy, I have a few questions for you. Do you have an attorney?
Yes.
Who is your attorney, Mr. Hardy?
I don't have one that's that I pay for. I have the attorney that's representing me now.
Okay, so you do not have the money or other means to hire your own attorney?
Not at this moment.
Okay, Mr. Hardy, have you received a copy of your indictment?
Yes.
And have you read and understood the indictment?
I'm dyslexic, so it's hard for me to actually read from time to time.
Okay, do
And-
you understand what you're being charged with, Mr. Hardy?
Yes, she read it off for me. Robbery and murder of a cop and foster parent.
Okay. Mr. Hardy, at this time, I am going to assign counsel to represent you. I'm going to assign the Office of the Public Defender, as well as Attorney James Ingalls to represent you. Because of the nature of these offenses alleged, the court will assign 2 attorneys to represent you. Your bond is set at $10 million. That is a cash surety property bond. You're ordered to have no contact with the surviving victims or any of your family, considering the victim's family is your family. I accept your not guilty plea. Your case is assigned to the docket of Judge Ashley Kilbane. First pretrial is on July 24th at 9 a.m. That's it for today, Mr. Hardy.
Thank you, Your Honor.
Thank you, Judge.
Thank you.